Hey everyone, sorry I'm late. Is Luis here?
Yeah, he's
Oh, there he is, okay. Judge Delano had asked that she have a little bit of time to speak to us today. I don't know if she's still on the bench or...
She's right there.
Oh, she is? Okay.
Wake up.
You go first or at the end?
How much time do you need?
5 minutes.
Oh, okay. Well, then you got, I thought you had more than that today. So, Luis also has a case he's going to present. I guess just came down from the 11th Circuit yesterday. So,
You want me to go first?
go ahead and go first. And then I'll just do a couple of announcements, and then that's all I got for today.
Cases. Super.
All right, David had asked me to give us a brief summary on a case that was decided by the 11th Circuit. The opinion was delivered just yesterday, and it's the case of In Re Custom Contractors, LLC. It's available at 2014 Westlaw 1226852. And then the slip opinions, it's case number 12-16489. And, I guess for better or worse, it's a case that's probably not going to have much impact on most of our practices. It's probably going to impact more the trustees and then the IRS. The holding in the case is that the IRS is not liable as an initial transferee as to prepaid taxes that would have been otherwise avoidable. And that's extending the the 11th Circuit's mere conduit jurisprudence. I think this was a case these were avoidance actions that were brought by Deborah Minot in Palm Beach. She had a debtor who was a sub-S corporation, and the pass-through taxes were paid by the corporation for the benefit of the debtor, or rather there were prepaid payments. And there were 8 transfers that were at issue. Ultimately the debtor had no tax liability, and I think that that's a fact that is relevant and probably distinguishable. But the court cited its earlier decision in Martinez v. Hutton, which sets out sort of a two-pronged test for the mere conduit, two-part mere conduit test. And so to defend against an otherwise avoidable transfer as a mere conduit, the transferee has to show first that they didn't have control over the assets that were received, and second, that they acted in good faith and as an innocent participant in the transfer. As to the IRS, the 11th Circuit, on account of prepayment taxes, the 11th Circuit analogized the facts or the situation to one as a bank with a deposit account. Because the prepaid taxes were always subject to refund in the event that there was no ultimate tax liability when the return was filed. The IRS at the time of the transfer didn't have sufficient control over the money such to be a transferee. And in this case, there was never a tax liability and the monies were refunded to the debtor. So the court held that the IRS on those facts is akin to a bank with a deposit account. The bank, the IRS, much like a bank, was deposited the funds into the Treasury. It was commingled with other funds. The Treasury was free to use the money, much like a bank is, for appropriations and things. But ultimately, the tax payment was subject to the refund provisions of the Revenue Code, and thus, court held that they were a mere conduit. I don't know if the ruling would have, I would think the ruling would be different if there was a tax liability, or if you knew perhaps on, as of the first quarter where there was the prepayment, whether there already was a tax liability, the facts would be different. But the 11th Circuit also touched on a couple other points that I think are interesting, but are sort of, again, more remote to our practices. Dealt with sovereign immunity in the context of the 544B1 requirement. 544B allows a trustee to pursue any avoidance actions that an unsecured creditor in the case could pursue. And so that's how the trustee is able to pursue the fraudulent transfer actions under Florida's version of the Uniform Fraudulent Transfer Act. Effectively extends the statute of limitations from 2 years under 548 to 4 years under Florida law. And there's some states, New York, for instance, has a 6-year clawback period. Although the court didn't get there, it considered whether sovereign immunity would bar a claim against the IRS in that context. The court first, sort of restated its prior jurisprudence and holdings that the government had waived sovereign immunity for purposes of 544, 548, and 550 actions in 106, but discussed the issue of whether the trustee would still need to prove that this is a claim that could be brought by an unsecured creditor. Because outside of the bankruptcy context, the government argued that sovereign immunity would bar the claim. And interestingly enough, the Seventh Circuit published a decision just last month, I think it was February 20th, that held that sovereign immunity does bar and that the trustee does have to prove that there's at least one unsecured creditor that could bring the claim that they couldn't in this case. And so that's basically that case. In Re Custom Contractors LLC was decided yesterday. For those that aren't following, this is sort of outside of what David asked me to talk about, but before I walked over, it's of interest to me. I know it's of interest to almost everybody. Sinkfield case. The briefs are in on the issue of whether cert should be granted, and it's scheduled for conference tomorrow. So certainly if cert is denied, we'll know on Monday morning, 9 a.m., they release the general orders. Presumably, if they don't want any further briefing, they would grant cert on Monday also. For those not familiar with the Sinkfield case, that's Bank of America's sort of collateral challenge to the holding in McNeil and Follendor. The McNeil petition for rehearing, I think, is still pending. There's no mandate in that case. Bank of America sort of did an end around and has a petition for cert pending in the Supreme Court. There was the petition and there was a petition filed and a brief. It was distributed for conference in late February. The justices requested briefing from the appellee, so the debtor. That's filed. Bank of America filed a reply brief, and then also the National Association of Consumer Bankruptcy Attorneys, NACBA, filed an amicus brief. So presumably we'll know something on Monday. All right. Any questions on either of those? My job is done. Thank you.
All right, just a couple of announcements, and then I'll have Judge Delano take the floor, and she can have the rest of it. As of right now, we're now listed on the Florida Bar's website as a local bankruptcy bar association. So if you need any information about who the current officers are and whatnot, it'll just be updated on that website. Let's see. Attached to the appointment meeting for this thing was a letter from Judge Gentleman talking about the Judicial Liaison Committee that we had last time she was in town. If you haven't got a chance to read it, it looks like she took our suggestions to heart and considered a lot of them, and some things are not going to go anywhere, and other things are going to be followed up on for further consideration with the Local Rules Committee. So we'll see what comes from that. Your officers had a meeting a couple weeks ago regarding a request from the Florida Supreme Court to all local bar associations to do a provision or a mandate that all events be held in a handicap accessible location. So we did that. That's now a rule. Anytime we have an event, it has to be accessible. And finally, I went to a bar association sort of meet and greet at Ave Marie last week. Yeah, so we have a visitor here from...
Right, we do have a visitor, Laura Wesley. She's Director of Career Services, whom you met at that meeting at Ave Marie School of Law. And thank you for coming. Thank you.
Yeah. One of my goals is to get more active with the law school, since we are able to have law students represent pro se debtors that may not otherwise have representation. It could be something that the debtors councils may want to have a little assistance in the office, maybe do some pro bono cases to get the cases in the door, and have help assist a law student work through the cases. Just become a little more involved with our local law school that's in our backyard there. So I'm thinking about potentially getting a professor to come in here and talk about secure transactions, and maybe bringing his class in, and he'll teach his class effectively that day for our meeting related to bankruptcy topics and secure transactions. That's something for the fall, but we'll look forward to doing something like that and becoming more involved with the law school. Other than that, I really don't have any other decisions. There was a decision that, two decisions that we were involved in. I came in down from the middle district. Fortunately, our firm lost both of them, but one of them was very, very fact-driven, so I don't know that it's going to have much applicability because it's very, very specific to the facts of the case, but it dealt with DSOs. Congratulations to Mr. Hollander on the win on that one. The other one is in Ray Valone. That was a decision regarding whether or not a Chapter 13 is different than a Chapter 7 with respect to keeping the home and claiming the wild card exemption. That came down in favor of the trustee. However, that will be then now going up to the 11th Circuit. So we'll see where that one goes from there. Yes.
Dave, I got a couple of things. Can I?
Yeah, absolutely.
For those of you who did not attend, and I know that I saw some of you there up in Orlando a couple of weeks ago, there was a mortgage modification mediation summit. And it was a very productive meeting. It brought together constituencies from the Northern District, the Southern District, from Tampa, from Fort Myers. And one of the things that they're kind of focusing in on trying to do is to get some uniformity throughout the state to the mortgage modification mediation project. One of the things that they brought up that I think is going to be immensely helpful is the use of a portal system whereby the debtor can upload documents to an off-site portal, and the providers, all the lenders, will have all of their information on the portal, the RMAs and all of the additional documents that they request, and it's there. So they can't come back later and say, you didn't provide this to us, you didn't provide that to us. It'll all be uploaded into the portal for everybody to see, and it'll provide for an exchange back and forth that should be expedited rather than doing it via telephone or fax or even snail mail. The things that still need to be vetted with respect to the portal are who's the provider going to be, and we'll probably likely go with the provider that the Southern District does, and then who bears the cost. And I think it's somewhere in the range of $40 to $45 per case, so it might be something that the debtors need to absorb just to demonstrate good faith in the case. The second issue that they brought up as part of this mediation project was adequate protection. What is adequate protection, and what should adequate protection be under the proposed model plan? We know that we pay 31% of whatever gross income is. There are some districts and divisions that deduct out from that 31% homeowners association and condo owners association fees, which is kind of in the HAMP guidelines, so there's some underlying basis for that. And then there are some divisions that don't provide adequate protection at all. I believe up in Jacksonville, unlike the plan that we use, they don't provide any adequate protection during the modification period. I'm inclined to think that we'll probably uniformly go to the 31% that we're adopted and have used here under the HAMP guidelines. But I think the real question is what is 31% going to consist of? Do you get to deduct out the association fees or don't you? And I think that's something that there has to be some discussion about. The next item that they brought up was the mediators. And I've had some great success thus far dealing with mediators. I know Holly does a great job, and I know that Bob's going to be starting to do this as well, and Paul Millay does a fantastic job as well. But what are the fees? What fees are going to be allowed? Because in the Southern District, They receive, I believe it's 600. Presently here, it's 350 with cost split between the debtor and the lender. And there's some question as to what the fee should be and what the hours of service would be. Would it be a 1-hour mediation? Would it be a 2-hour mediation? And I think we're probably generally trending towards that. Paul?
I'm sure you know this, but the way they do it in Southern is they allot 2 hours for
Right.
mediation, but it's by phone.
Yeah.
1 hour, and then if that doesn't get resolved, then they schedule for another.
And then after that, it would be at the mediator's normal hourly rate, which makes sense because there's a lot of time and effort that go into these. Some of these are relatively brief, others are going to be more in depth, so I think it makes sense kind of handling it that way. Then they talked about once the mediation modification is approved, what do you do then? There are some jurisdictions that are presently require it to be paid through the plan. Right now, I don't think we've got a real definitive position from the Chapter 13 trustee's office as to how they deal with it, but we have to factor in that we have to pay 10% on top of everything, and that's a concern that I would have from debtor's counsel position is that if we do get a modification approved, we should probably have a mechanism to then pay directly, but there were generally competing theories on that there as well. If it's denied, which is something that I really didn't think of until I went to the meeting, but they talked about certain surrender options that the lenders were amenable to. In some instances, it might have been a cash for keys type of transaction, or it could have been an extended foreclosure sale date. A number of different things that they'd be willing to do, deficiency waivers, things like that, that I think would be beneficial even for those debtors who probably don't have a real solid chance under a financial feasibility of getting a modification through. They might want to do it for these potential surrender options. And then the effective confirmation, would we be amenable to having the plans confirmed while the modifications are still pending? And I think that's still kind of floating around out there and is still yet to be decided. But from all indications, it looks like it's going to be something that would be very useful in a consumer Chapter 13 practice. So if you haven't come up to speed on it, it's probably something you want to. I believe, and I may be wrong, but Judge Delano, I think there's going to be a task force appointed that's going to try to pull in the different divisions and get some kind of uniform application. And I think that's the direction that we're going, and I think it's going to be a good thing for debtors. Ultimately, if we can save a couple of folks and keep them in their houses, the project is worth it. So something to think about. 2 other cases that came down in this division that you probably want to be mindful of if you are either a Chapter 7 or a Chapter 13 practitioner. And these are Mr. Hollander's cases, one in his favor, one against. The first being in re Stillwagon.
Actually, I won both of them.
Well, kind of. You lost, but you won ultimately. Stillwagon, and the issue in that case was there was a debtor who filed her petition in schedules. She had an interest expectancy interest in her mother's passing, but at the time she filed, her mother was perfectly healthy. There was no reason to think that she was going to pass away at any time. The Chapter 13 progressed, it got confirmed, and then approximately 6 to 7 months afterwards, her mother passed away, and she became entitled to receive death benefit from her passing. The issue that ultimately came up was in the Chapter 13 trustee moved, I believe, to amend the confirmed plan, seeking distribution of the inheritance. And under the provisions of 1306, property of the estate in Chapter 13 is much broader than it would be in Chapter 7. In Chapter 7, we know that we're dealing with 541 property, and the exception to that being if they become entitled to receive an inheritance or a death benefit within 180 days, that becomes property of the estate. But Chapter 13, the property of the estate, the distinction is it continues throughout the life of the plan, either to plan effect payoff or consummation of the plan and finishing of the plan, or dismissal. So once the Chapter 13 trustee sought to seek administration of the inheritance assets, the debtor converted her case to Chapter 7. The Chapter 7 trustee opposed it. asserting that it was a conversion in bad faith. And the analysis of the court goes into what is essentially bad faith under those circumstances. And the language that is used is, and I advise you all to go back and read through the opinion, it's a very well-crafted opinion, and I think it touched well on all the points, is that Section 348F2, which is the bad faith provision, is to ensure that a fraudulent, deceptive, or dishonest debtor does not contravene the purposes or spirit of the bankruptcy code. However, the court determined after testimony of the debtor that where a debtor has deliberately abused the bankruptcy process by filing initially under 13 with the intention to thereafter convert to a 7 in order to shelter an asset that the debtor expects to acquire shortly after filing of bankruptcy, that would constitute bad faith. But under the facts of this circumstance, when the debtor filed her petition, she did not have any expectancy that she was going to receive this money, and that she could not have intended to game the system when she filed the Chapter 13 petition. So it alludes you to the fact that you look at intent when the Chapter 13 is filed to determine whether the conversion to Chapter 7 would be bad faith. And this is going to be largely factually driven, but it's something that you probably want to pay some attention to. And the second case, I'll just give you the case site, because I don't want to take up all of Judge Delano's time, is In Re Adams, and that is case number 10-15218, and it had to deal with whether a debtor has a right to amend their schedules post-confirmation. So it's the interplay between 1327A, the binding effect of confirmation, and Rule 1009. Ultimately, the court made the decision in this particular circumstance that 1327A controlled, and because the debtor had the ability to amend any time prior to confirmation or disclose initially, that you couldn't later go back and do it after confirmation. Probably a good decision as well. We all know what the binding effects of the confirmation order are. So ultimately, if you just dismiss the case and refile, I think you kind of get to the same result.
By the way, you were correct, Greg. I won one and lost one.
They're still batting 500.
That's all I have. Oh, I brought copies of the model Chapter 13 plan that is getting circulated, the national one. I hadn't seen it until I went to Judge Pasquet's seminar. It's got some unique provisions, and it's still fluid. They're still working on drafts of it. But it's something that, if you haven't put any eyes on it, you might want to. Courtesy of ABI, I printed out just a couple of copies out of mine. So if you haven't seen it, I'll just leave them up here if you want to grab it.
Yeah, that was a good sum.
I thought that was worth it too.
Ready for me? Great. Good afternoon, everyone. I want to follow up on a couple of Greg's comments. One on the Adams case that he was talking about. These, of course, were my decisions. The debtor, post-confirmation, wanted to take an additional exemption. That really was what the interest was.
Yeah.
Or what the proposed amendment was, and that's where the debtor got stuck. So perhaps that case has been dismissed now. I don't know. Anyway.
I think we're going to, I don't remember what we
Whatever.
I don't remember what we're doing with it.
As I like to say, file something. Anyway,
We'll
it'll all work out. And interestingly, on the Singfield case, I read a really interesting blog post about the NACPA amicus brief, which basically was urging the Supreme Court not to accept cert. And the argument was that the case had arisen in a very artificial way because at the bankruptcy court level, the bank and the Bank of America and the debtor had stipulated to the entry of an order. It then went up to, I think it went on a direct appeal to the 11th Circuit, I think. And at the 11th Circuit, they agreed to a summary adjudication and affirmance, and then it went up to the Supreme Court. So it's not your typical hard-fought, hard-battled case. So it'll be interesting to see what happens with Singfield. It also will be interesting to see what happens if the Supreme Court does accept cert, because as you all know, the bankruptcy judges in the Middle District have decided that, notwithstanding the fact that the McNeil opinion is out there, we're waiting now since last August for a ruling on the petition for rehearing en banc, we've all decided that we will lien strip in Chapter 7s. If something is actively going on, it's possible that we'll all take a change in position. Some creditors are filing their own notices of appeal. And if they do that and then they seek a stay pending appeal, I had one of those come up before me. I know Judge May had one come up before him, and that prompted a discussion among the Tampa judges. We basically are willing to enter a stay pending appeal. Whether it's necessary or not seems to me to be another issue. But if a creditor goes to the trouble of filing a notice of appeal, then we are willing to enter a stay pending appeal generally. I wanted to just mention the ABI Stetson Pasquet Memorial Seminar that was a couple of weeks ago. We had, I think, 15 people from Fort Myers up there, which was a really good showing. It was, I think, a very strong seminar this year. Everyone that was there seemed to really enjoy it and had a lot of really relevant programs. So the two people that get the most credit for that are Judge McEwen and Judge Williamson. They were the honorary co-chairs, and they really designed the program agenda, so I think they did a really good job with it. The other thing I wanted to mention, following up on what Greg was saying, was this mortgage modification mediation summit that was in Orlando. What is going to come out of that is, I'm not quite sure because this has not been my project, but Judge McEwen has really been heavily involved with it. Judge Specie from Northern District came, Judge Hyman from the Southern District came. And there was a goal of coming up with uniform procedures. Representatives of the major lenders were all there. High-level people, Wells Fargo, Bank of America, Ocwen, I think. So there were representatives of the lenders. And they basically were saying it would help us if everybody had the same procedures so that we knew how things were being handled in the state of Florida. I believe that there is going to be some sort of an agreement or white paper floating around that's basically a unified statement of how mortgage modification mediations are going to be handled in the state of Florida. The one area on which I think there's likely not to be agreement is going to be the matter of mediators' fees. And that's just because different jurisdictions and locales have such different ways of handling that. But generally, as Greg mentioned, the portal, I think, is an overwhelmingly accepted idea, and I think that we'll be moving to that. And the other thing that we're moving towards, and I think it takes a little bit of a buy-in from the Chapter 13 trustees, but in other jurisdictions, courts are willing to confirm plans subject to mortgage modifications. So in other words, the plan gets confirmed, and then if something happens and the mortgage gets modified, then the plan gets modified down the road. And the fact that a mortgage modification mediation is dragging on for months and months doesn't need to stop the plan from going forward. So anyway, that should be coming out, I think, sometime in the next month or so, and I think that'll be a really helpful guideline for everybody. Speaking of Chapter 13 plans and the national model plan, I understand from John Waggy that he's going up to, I think he's going to Texas or someplace for a big meeting in the next week or two, and hopefully we'll have some more news on that. In the meantime, Mr. Waggy and Mr. Smith and I have been working on some tweaks to our form model plan that I think just make it a little bit easier to use. So they've just given me their final okay this morning, as a matter of fact, on a draft that I had circulated to them. I'll be taking it up with the other judges in Tampa this following week, and it's very likely that in the next week or so, you guys are the first to know, no one in Tampa knows this, it's very likely that in the next week or so, there'll be a new form of model plan. It's nothing new, it just combines some areas and makes some things a little bit different, a little bit easier to deal with. One of the things that it does address is the situation of what happens to the adequate protection payments that the debtor is making in the Chapter 13 plan when a creditor doesn't file a proof of claim. And what the experience I've heard from the Chapter 13 trustees is that if the creditor hasn't filed a proof of claim, if they disperse to those creditors, then the creditor sends the money back. So it just creates a problem in terms of how does the money go back to the debtor, what happens. And so kind of the compromise that the trustees are willing to work with is that as long as a proof of claim is filed before the earlier of the claims bar date or 14 days after the date of dismissal of the case, the money goes to the creditor. Otherwise, the money goes back to the debtor. So the order dismissing the case is going to lay that out, as well as the model plan. And I think that'll probably make things a little bit easier too.
So they
Yes.
just escrow it until the claim hits, and then they'll pay out?
Well, which is what they do anyway. David?
Is there a provision or any way to sort of hold the lender's feet to the fire to mediate in good faith on those payments, though? Like, we've had
Oh,
situations
subject to
where-
objection by the debtor. I mean, in other words, if the debtor disagrees as to what the amount of the payment is, for example, if the creditor files a claim and the debtor disagrees, the debtor can object to it. But generally, what you're talking about is a Chapter 13 plan that provides for adequate protection payments to be made to the lender. That's kind of the price that the debtor is paying for getting the automatic stay. If the case gets dismissed, the claims bar date wasn't a 13, I forget, is it 180 days? It's a long
Can
way.
be, yeah.
It's a long ways out there. If the case gets dismissed in month 4 or month 5, what happens to all those accumulated payments? If the creditor has filed a proof of claim, then those payments get made to the creditor. And essentially, what the dismissal order is going to do is to give creditors who haven't filed proofs of claim notice that if the claims bar date hasn't expired yet, you've got 2 weeks to get your proof of claim on file, otherwise the money's going to go back to the debtor. So that's the thinking.
The claims bar date's 90 days after the creditor's meeting, except for the governmental entity, which is 180 days.
Right, but 90 days after the creditor's meeting, once the creditor's meeting, sometimes they go out way far.
Now, 13 is 30 to 45 days after filing.
Okay, my recollection is, I could be wrong, but I see a lot of cases where the claims bar date is pushed away, is close to 5-6 months. So it's 100 and,
It's almost 6 months.
Right.
It's 150 days.
okay,
By, if you end up on the 60th day,
right,
you're at 150 days.
right, okay, so that's almost,
Yeah, you're
that's
anywhere.
5 months.
Well, between 135 and 160.
Right, so that's a good 5 months.
And
And
Jen-
lots of cases are dismissed, month 2, month 3, month 4, and the debtor may have made payments during that time period.
And generally, Mr. Waggy's office will wait until the governmental claims bar date passes, so it'll be a full 6 months before
It'll be
it'll
6
move.
months of date filing.
Right.
Before it moves to
Right,
confirmation.
right. Certainly before it moves to confirmation, but a lot of these cases die on the vine
It's true.
before they come up for confirmation. The debtor changes their mind, the case gets dismissed because the debtor isn't making plan payments. But if there's any money being held, it's supposed to be distributed as adequate protection payments under the plan. So in any event, in the next week or two, you should be seeing something new coming out on that. Just a couple of practice pointers. Most of you, I think, when you're filing documents CMECF, you convert the document to a PDF. So like on your computer, you're in Word, and then you can convert it to a PDF, and then you upload the PDF. Some people, I don't quite know why, like to scan in what they've prepared, and then they upload in the scanned document. I have to say, from a professionalism standpoint, the converted PDF documents look much better than the scanned-in documents, number one, and they're much, much easier to read. As a practical matter, a converted PDF document takes up much less room on your computer memory, whatever, I'm forgetting the term for it right now, okay, than a scanned-in document does. And the same with the court system. Now, we have, I think, unlimited ability to maintain documents, although I know that some courts have gone to requiring all documents to be converted PDFs, other than exhibits, which have to be scanned in, but any created paper filing needs to be converted to a PDF. So I thought I'd just mention that to you, because when you look at it, those of you who scan in your documents, click on the docket and take a look and see what it looks like, because it looks terrible, okay?
Except it has a signature.
I don't care about a signature. //S/. That's a signature. That is a signature. And that's going to segue, although, to one of my next topics, which is going to be local rules. As you all know, I kind of spend a lot of time on local rules. So I'll get to that in just a moment. So anyway, that's just something to think about. Something else that has come up in the last several trials that I've had this week and in prior weeks, I don't think attorneys, I don't think attorneys have a great understanding of what they need to have in terms of exhibits, okay? So when you're preparing for a final evidentiary hearing, you just have to keep in mind who you need exhibits for, okay? You need a set for the witness, you need a set for opposing counsel, you need a set for the courtroom deputy, that's the official exhibit book, and you need a set for me, because I'm busy tabbing them, marking them up, highlighting things, that's my working copy. A lot of times people bring that number in, they forget they need a set for themselves. So You need 5 sets of documents. You, the other side, the witness, the courtroom deputy, that's the court, the official set, and for me. So 5 sets of exhibits, so just kind of think about that. Talking about local rules, you probably all received the CMECF notification a couple of weeks ago that proposed new and amended local rules have been posted on the court's website. There's a public comment period. That comment period runs through April 18th of this year. So I really would urge you to take a few minutes and take a look at those local rules. When they are promulgated by the judges, they'll be effective July 1st, 2014. There will be another notification that goes out 30 days in advance of that, putting everyone on notice that the new amended local rules are about to go into effect. Just to give you a highlight, some of them are just tweaks of rules and some of them won't impact that heavily upon you. But I wanted to give you kind of a summary of the highlights. One is a tweak to the negative notice procedure rule, Rule 2002-4. There's always been this question, are additional days added for mailing when you serve something on negative notice? And as a practical matter, the clerk's office counts it's 21 days, and then we won't enter the order until another 3 days have expired for service. The problem is the person who's the recipient doesn't know that they've got that additional 3 days in which to file a response. So we're changing the negative notice legend to provide for an additional 3 days for service. So it's 21 days plus 3 days for service. Doesn't make any difference how it's served, even if it's served CMECF, 21 days plus 3 days for service, then we're all on the same path with that. The other thing is that orders are supposed to be submitted then within 3 business days after the expiration of the response period. Now, that goes into our proposed order rule, which is Rule 9072-1. A request that percolated up through the Local Rules Committee was, right now the local rules require that orders after hearings be submitted 3 days after the hearing. So if you finish up a hearing Friday afternoon at 5 o'clock, your order is supposed to be there Monday. Maybe it's not possible. Anyway, it's now 3 business days after the date of the hearing. Now, I like to say that's a rule that's honored more in the breach than, in terms of actual compliance, but that should be a goal.
On
Yes.
that one, I thought Judge Gentleman's letter had said that.
Service. That was different. Hers wasn't uploading the orders. I think her letter addressed service of the orders. Okay, I think that's 2 different issues. And I have to tell you, I had to double check that myself because I thought the same thing when I saw her letter. The other changes to our local rule on orders, the amendment's going to clarify all the information that's supposed to be in proposed orders. And that's basically it, but it's a complete rewrite of the rule. It directs attorneys to the website, to the court style guide. So you're going to want to take a look at that. Rule 2004-1, 2004 examinations. We've been talking about this for some time, and there was a steering committee that then made some proposals, and that went up through the Local Rules Advisory Committee and now has been approved by the judges. So the new rule basically adopts Southern District's rule, which is no need to file a motion for a 2004 exam. You can file a notice of a 2004 exam, but the examination has to be at least 21 days after service of the notice. I don't know if the Southern District requires that their 2004 exam notices be filed on the docket. We do require that they'll be filed with the court. If someone wants to tag along to the 2004 exam, they need to give a notice they need to file a cross notice of a 2004 exam. That's to give the debtor or whoever the examinee is notice of who they can expect to be there. And if you get served or your client gets served with a notice of 2004 exam and you object to it, then you file a motion, an emergency motion for a protective order that the court will schedule as quickly as possible, and everything is stayed pending that ruling. Obviously, the parties themselves can agree to anything they want to, but instead of going to a motion order, a motion would come in, the court would know, do we hold the motion? Do we see if there's any objections? Do we go ahead and enter an order right away? This way it just clarifies so everybody knows what the rules are. Greg?
Did we end up deciding whether we had to put a date into the notice of the 2004 exam? Or there was some question suggested by the parties, agreement by the parties?
No, you put a date in or a date agreed by the parties. Okay, probably, because it's at least 21 days out there, so you're going to need to calculate that date. And Rule 45 subpoenas apply the rules governing subpoenas apply to service of the 2004 exam notice. And if you want documents produced, you can get them produced in advance, but at least 21 days after the service of the 2004 exam notice. Luis?
Rule 45 is going to apply to the debtor also?
Not to the debtor.
Not to the debtor.
To non-debtor examinees,
And
right.
this is effective July 1st?
It will be effective July 1st. Now, if you care about this, you need to go on the court's website and you need to, hit on the link to comments. You need to make some comments because this is all out there for public comment. So I hope you'll take a look at that. The other thing that's up there is an amendment to Rule 3020-1. That's the rule that governs Chapter 11 confirmation. And we're going to require that there be essentially an integrated plan document or integrated order confirming the plan that contains all of the terms of the plan. What has happened in the past is we've had, particularly with the individual debtors, sometimes with business debtors as well, let's say an individual debtor owns 20 pieces of real property, each one has 3 mortgages. So debtor files a plan, and then debtor's attorney is doing a really good job over the course of the next several months. Sometimes this is a process that lasts 3, 4, 6, 8 months long, cutting deals with creditors. And every time a deal is cut, the attorney files a modification to the plan or an amendment to the plan that only addresses that one class of creditors. So then when the case comes up for confirmation, then the confirmation order is entered. Well, later, if there's a dispute post-confirmation as to what the plan says, instead of just looking at the plan and the order confirming the plan, we have to look at all these interim modifications and make sure or amendments to make sure we haven't missed anything. So, not a problem with filing those one-off amendments, but at the end of the day, they've either got to be incorporated in a comprehensive amended plan, or they need to be incorporated into the order confirming the plan. So at the end of the day, if you want to know what it is the court confirmed, you look at the confirmation order and the most recently filed plan, and those will be the only 2 operative documents. So I think that'll make life a little bit easier for some people. For the first time, we're going to have a local rule on automatic stay provisions. It's new local rule 4001-1. If you read the Court Connection, which is the court newsletter that comes out, it kind of laid out what the clerk's office procedures are for processing motions for relief from stay, and they've been incorporated in this local rule. So I think that'll be helpful. That'll be, of course, district-wide, which will make it easier for those of you who practice in different areas as well. 9011-4, signatures. This governs the topic that you brought up, Richard. The question of original signatures. There's a new amendment to that provision that allows an attorney to file an electronic signature of another party, such as another attorney, with the filing attorney's attestation that he or she is authorized to do so. So when you have a stipulated order or a stipulated or a stipulation, instead of having to fax around copies, or maybe you have 6 signatures that you need to attach and you don't want to have 6 signature pages because everybody signed on a different copy or something like that, you can use the electronic signature, but you are attesting that you in fact have the authority to use that signature. So I think that'll kind of clean up some of the documents. So I'm not sure what the real concern is about having original signatures on documents, because I haven't seen a problem. One of the things I know that we're looking at now, somebody raised the issue of the fact that our current rules require that when the debtors file, when you represent a debtor, that you have to maintain the original signed documents for 4 years, and that's considered by some to be a burden, and so that we're kind of looking at that. You have to realize those rules are first enacted as we go to electronic filing, and the world's a lot more sophisticated place than it was 10 or 12 years ago when we first started the CMECF system. So anyway, please take a look at those local rules. I welcome your comments. We go through every single one. What happens is when the comments come in, they're essentially collated through the website, and then they're reviewed with the Local Rules Advisory Committee, and then the Local Rules Advisory Committee makes recommendations to the judges. But you should be hearing probably about June 1st. You should get a CMECF notification with links to the rules that will be in effect on July 1st. So moving ahead with that process. Other than that, I think that's everything I had. Anybody have any questions?
If an item is not specifically on the negative notice list.
Do not file it on negative notice.
Okay, that's what no matter.
No matter what, don't.
Okay,
Don't.
okay.
Now, I've said this before.
Yeah,
There will be a day, I'm not sure when it is, 18 months, 2 years, 3 years from now. There will be a day when we will not have a negative notice list. There will be a day when everything will be on negative notice. But well, you know what a change that is compared to the olden days when absolutely everything got set for hearing. And, when you have a calendar of, 150 unopposed motions, you realize, why are we all in court together? They're not opposed. So eventually, I think everything will be on negative notice, but it creates a real glitch in the system when something's filed on negative notice. It's not on the list because then the case manager doesn't know what to do with it, and they send it up to chambers, and sometimes the judge lets it fly, and sometimes the judge doesn't. Sometimes I think the procedure now is just to go ahead and set them for hearing if they're not on the negative notice list. It used to be. I'm trying to think exactly what the procedures are. Sometimes the court would enter an order denying the motion because for inappropriate use of negative notice, and then the question is, then do you start the negative notice clock starting up all over? You start that clock ticking all over again, give somebody another 21 days to respond. That doesn't make too much sense. And you can avoid all that if you don't use negative notice when it's not on the list. So, and we're trying to keep all of those things updated. One thing that we're learning as we're going through this effort to have the district be very consistent procedure-wise is that there are lots of places where things are, and we have to remember to change them in all the places. And that's why we're sort of trying to reference the one place where something is kept. For example, the Rule 2002-4 on negative notice. It used to be the original rule laid out the 4 or 5 things that were authorized to be served on negative notice, plus whatever the judges allowed. That's pretty vague. And now the rule just says, refer to the negative notice list on the website. That way we don't have to change the local rule every time something gets added to that list. So, and that list, I think it's been updated about 10 or 12 times over the course of the last couple of years. So anyway, that's all I had, but hey, yes.
One more thing, Judge, backing up to the mortgage modification
Yes.
mediation, throw out for public consumption one more time what your no-look fee is. It's terrific incentive to.
$1,800
On top of your fee.
on top of, $1,800, and that's not the mediator's fee, that's the debtor's attorney's fee for participating in the mediation. And that is whether the mediation is successful or unsuccessful. So,
We've been adding them into our plan up front, into the
okay,
portion of the plan.
have you
because-
been having any problems with that?
No, and
Okay.
I don't think we're gonna see any, because we filed a motion to mediate almost simultaneous with everything else.
Oh, that's another.
You can't do that.
Yeah, I don't think Mr. Waggy wants you to do that. Let me tell you, here's something else that's interesting, because this was something that came up at this conference. My feeling had been, file your Chapter 13, file your motion for mortgage modification mediation right away. No, guess what we hear from the big lenders? They can't deal with it that quickly. And so essentially, very, very interesting, and it's gonna end up changing perhaps our plan again, because right now we have that 6-month window where the debtor gets the automatic stay for 6 months. That's probably gonna end up going away, okay? Because the creditors don't even want the motions filed, I think it was 90 days after the case is filed.
And the
Okay.
portal's gonna be huge.
And the portal will be huge. It will the process will be facilitated. But that just flies in the face of everything I had thought. I had thought, get that motion on right away. Let's get started right away. And it may be that their position was 90 days or when a proof of claim has been filed, whichever is sooner. I think that might have been part of it. Paul?
Judge, I think that's probably more on the residential side, because I know I represent a lot of lenders that have commercial mortgages. And-
That's a whole different world.
Yeah,
Because
and-
then you have special asset people that are working on it from day one. But, when you hear the stories of the major lenders and how many people they're supervising, you can see from their perspective, what a real headache it was. But I was very happy to see what I thought to be a real commitment on the part of the major mortgage lenders to participate in the process and to get this worked out. And, you know, you probably have all thought about this before, but from the judge's perspective, we're really looking at this as probably a 2, maybe 3-year window of opportunity to get this done, because property values are starting to climb back up. And right now, you know, some people's properties went down, values went down so far compared to what they paid for their houses and what they borrowed against their houses, that, you know, even though property values may have increased significantly over the last year or two, they're still way underwater. Presumably, over the next couple of years, those houses aren't going to be underwater anymore, and the debtors aren't going to have quite the same ability to negotiate a reduced principal balance on their loan. So, anyway, it was very rewarding to see that the lenders did seem to be interested in pushing this process further and not creating roadblocks. And I would have thought this 90-day requirement was a roadblock, and I, you know, would have been a little annoyed about it. But I can understand from their perspective, it takes them a while to get organized. So, anybody else have anything? No? All right. Well, thank you all. Thank you for the opportunity.